Afternoon, everyone. My name is Joanne Mallon. I work in the business engagement team here at Queen's University, and I am delighted to welcome you all here to this online innovation workshop entitled From Ideas to IP. And this workshop is delivered as part of the InterTradeIreland All-Ireland Innovation Programme. Ourselves here at Queen's are really pleased to collaborate actually with two other university partners to deliver this programme of innovation talks and masterclasses. And those two universities are the University College Cork and NUI Galway. The InterTradeIreland All-Ireland Innovation Programme has been running for over 10 years. And we are delighted that it has helped to inspire a huge number of SMEs to adapt and use innovation as a tool for growth and development in their organisations. And I have no doubt that today's event will inspire you all also. Before I introduce today's main speaker, Dermot Tierney, I'd like to just outline the format of this afternoon's event. Dermot's main presentation will run through from now until about 1:20 p.m. If you have a question throughout the session, it's going to be very informal. Please pop it into the chat box on your screen and Dermot will refer to it when the opportunity arises. At 1:20 then we will have a 5-minute comfort break and we will kick off the next session, session 2 at 1:25 p.m. For those of you who are not able to stay on for the second session, we ask you all then just to leave the meeting and trust that you will have enjoyed the first session. For the rest of you who are staying on for session 2, we ask that you just stay on the call for the duration and we will kick off and or pick up where we left off then at 1:25. So session 2 itself will be a little more interactive and we're hoping to break you guys into breakout rooms to have a quick chat about some real life scenarios, perhaps talk a little bit about your own business or your own ideas. And before we return to a group discussion with Dermot, who will conclude today's event with some questions and answers and some tips, tactics and hacks for SMEs in particular. We hope to finish up promptly at 2:00. And this now brings me to the introduction of our speaker. Dermot Tierney is the Intellectual Property and Licensing Manager at Queen's University. He holds a BA from Ulster University and an MBA from UCD Smurfit and has over 18 years experience in the areas of business development and technology licensing. So without further ado, folks, I'm delighted to hand you over to Dermot to kickstart today's event From Ideas to IP. Thanks, Dermot.
Thanks very much. Am I on mute? Can you hear me, John?
You're all good. Yeah.
All right, good. I wasn't sure. My Zoom had went a bit skew. So look, thanks very much. I'm coming at this session really very much from an intellectual property practitioner perspective. So, just for the avoidance of doubt, I'm not a patent attorney. I'm not a copyright professor, an IP lawyer. I'm just a dude that works in the university trying to commercialize the IP that comes out of the university. And because that's my day job, I obviously have, very practical grounding in the reality of trying to manage this type of stuff. So to say, look, I work in Queen's, as Joanna said, and what that means is I work with our spin-out companies and I work with our licensee companies around doing deals and licensing out technology, intellectual property from the university. But the university actually has a lot in common, to be honest, with how we try and manage IP and the approach that SMEs could potentially take as well. Because despite what you might imagine, the university, intellectual property and generating intellectual property is not the core aim of the university. The university's aim is to teach and research. And actually there's little time and resource to be spent on managing intellectual property per se. So in some ways we have to operate in a very lean way. We have to manage and reduce costs. We think of IP as a future asset which will have a value at some point in time, but it's quite frankly not of any immediate help to academics that are working on their research right now. So so in some ways that's quite similar to how SMEs can work as well. And I've worked in, as well as working in Belfast, I've worked in Dublin for many years in the tech transfer space down there. So I can tell this story hopefully with a foot in both jurisdictions, and really from an intellectual property and a business perspective, it's really very similar. So look, what's the point? I was thinking about this presentation the other day, and I thought, well, look, I'm not trying to sell anybody anything in terms of the merits of intellectual property and spent a lot of time on it. But I suppose it's worth answering that question. First of all, what is the point in talking about intellectual property? Why should a business, whatever that type of business is, but particularly an SME, care? An SME has employees to pay at the end of the month. You're an owner manager and you have customers to service now. Intellectual property can be, people tend to think of it as a little bit more ethereal, tend to think of it as a bit vague, it's a bit out there, it's a nice to have, and it's not a must have. Well, I suppose the way I would frame it is, why do you service your customers at all? Why do you why do you manage employees and have them in the first place, if not to build value in the business? And really that's where IP comes in. IP is there to help protect that value. So IP is a key resource. IP is a barrier to entry. But it must be understood that IP doesn't create the value. In this context, the intellectual property is the umbrella. It's not the tree here. You create value by creating a product or service that customers want to buy and customers want to pay for. The intellectual property that you're able to build up around that offering is what helps you then protect that value that you've created. So that needs to be understood right at the outset. And for example, to give an example, and we talk about them a little bit later on in more detail, a patent is a negative right. It's a right that allows you to, it is a right in law that allows you to stop someone else doing whatever it is that you have patented. Use that apparatus, use that formulation, apply that method, whatever it is that's patented. It's a negative right to stop stop someone else from using that. It's not a license to print money. Just because you have your core of your product or service or offering or your pharmaceutical formulation covered in a patent doesn't actually mean that anyone will want to buy that per se. So 70% is really, I suppose, the number that I tend to think of most when I kind of talk about that question of why is it worth worrying about intellectual property? What value does that have? And this is a number that gets cited in a lot of research, and the number tends to float around from 70 to 80%. And what this number is I tend to take the number based on research a few years back from Northwestern University in the States. And they had research out at the time that showed that 70% of a firm's value may be represented in IP. They were analysing early stage companies, SMEs, innovative technology-driven companies typically, and their value at an exit. And they assessed that between their intellectual property, their software, their patents, their know-how, maybe their brand, 70% of that was tied up in intellectual property. Now, I would imagine that if you apply that to the time that you actually spend in your business doing all those things, managing employees, servicing customers, managing operations, you're not spending 70% of your time managing intellectual property. In fact, I'd be surprised if many people were spending more than 1% of time even thinking about the intellectual property aspects. And the moral of the story is, I'm not suggesting that you should spend 70% of your time managing intellectual property. It's really understanding that intellectual property is not going to be necessarily the basis of success, but it can be the basis of failure, for the business. And if you don't protect that value that you create, someone will come in then to eat that lunch. So if you spend just a little bit of time trying to get your processes, systems, and sort of thinking hat on, just being aware that everything you do has the potential to create value, and intellectual property around that can then protect that value. That's something to be aware of and something to think about, and that will get you hopefully a little bit ahead of the game. So in trying to explain, look, what intellectual property is, I like to think of intellectual property in terms of something that sort of everybody can relate to, because intellectual property seems, it seems legalistic. It seems like a bundle of things that, they're very specific terms like patent rights and trade secrets and, confidential know-how and licensing and all these types of terms. And people sometimes glaze over and turn off. But I think everybody understands things in the context of ideas and what their ideas generate and the value of their ideas and what their ideas can do in practical terms. So I like to try and sort of relate the intellectual property piece back to that a little bit. So it's easier to think of intellectual property as an extension of your ideas. So the intellectual property is simply a mechanism then to protect these ideas. Intellectual property itself is a bundle of laws and legal rights that exist all around the world, in pretty much every state, certainly every well-developed, well-managed state, has a bundle of these laws that all have great degree of commonality around the world. What these do is they help you protect the property of your mind, which if you're working in a university as a researcher, if you're working in an SME, a technology-driven SME, that's your most valuable property, to be honest. How you do things, the way you do things, why you do things, and how you use those bundle of rights, what you protect and when you protect it is crucial in order to give it, to help you sort of identify something tangible, something that can be codified, something that then eventually is licensable or scalable or exploitable at whatever point in time that is that you want to sort of extract that value from it in monetary terms. So, what is an idea? First of all, that's one of the things that, when I'm saying I really have back to ideas, let's just all first of all get on the same page about how we actually might define what an idea actually is, because actually I looked into this way back when I was sort of looking at this presentation previously, and there's a ton of different ways, different schematics, different formulations that actually define what an idea is. And the one that I like best, really, it comes down to the concept that an idea is simply the meeting together for the first time of two independent thoughts that form an idea. And what really interested me in that concept was that applying knowledge, applying learning, and applying experience, you have these two independent thoughts, they come together, and that forms the idea. And just intuitively, it's sort of reasonable to expect that, look, the more technically novel you are, the more innovative you are in terms of your knowledge, your learning, your experience, the more top of your game you are, either as a researcher or as a company that's developing technical solutions, the more likely that these ideas are going to be unique. And that sort of leads me on to the sort of the IP aspect, which then can be brought in, and you can protect these ideas and add that protective bubble around the idea as and when it's been created. That uniqueness leads me on to the first point that I want to kind of talk about before I get into a description, a breakdown of the different types of IP, what exists, what your options are, and so on. And one thing to understand about all the types of IP that I'll go on and talk about in a moment is that in my experience, there is two qualities that they all will pretty much have in common in some way, shape, or form. And obviously there are lots of wrinkles for different types of intellectual property assets, but they all have two core qualities in common. So number one is originality, or novelty, or newness, or uniqueness. They're all going to be new. If it's not original, it's probably not protectable realistically through really any of the forms of intellectual property. So it needs to be original, it needs to be original work in some way, shape, or form. The second thing is it needs to be confidential, at least to begin with, and I'll get a little bit into that, the idea of confidential to begin with or confidential later, and sort of different IP types of IP that might have distinctions there. But certainly at the outset, at the stage of conception, when you invent that thing, that pharmaceutical formulation, that new piece of software, at the outset, at that starting point, it's going to be confidential to you. You will have developed it, it will be original, and you won't have shared it with anyone else outside of the company or outside of the organization at that point in time, typically. So understanding that those are the two kind of common threads that will tie a lot of these aspects of IP together. What I'll do is I'll get into a bit more detail on an item by item basis as to look what are the different types of intellectual property assets that you can bring to bear on different types of ideas and different types of inventions and different types of products. I could spend the session going into detail on all of these different aspects, but it's probably half an hour per point almost to get into a really sort of detailed description. So I'll focus primarily on the types of intellectual property that I think are going to be of most interest and most important to the majority of SMEs, but obviously some SMEs will vary, and this also applies to a certain extent as well to the university context as well. I know there are a lot of university side researchers and academics on the call as well. So look, first of all, what is a patent? Because, and it's, we'll cover that first, because I think it's the type of intellectual property right that people most associate with intellectual property. They think of a patent and they can understand conceptually that it is an asset, it is a thing. Well, I like to relate it back to the idea. So what does a patent actually cover? What does that potentially protect in terms of your idea? Well, if your idea is a method, if it's a system, if it's an apparatus, if it's a formulation, if it's basically something functional, then a patent potentially can be used to protect that. And what a patent is at its core is a patent is actually a state-granted monopoly. And a patent is a bargain between you and the state, whatever country it is that you're in at the time that you're looking to patent this in. It's a bargain between you as the inventor, or indeed the applicant, if it's an organization that's applying for this. And the bargain is essentially based on this. It says, the state says to inventors, to innovative companies, to innovative people with great ideas, it says, tell the world about your invention, tell the world about what you do and how you do it. And in return for disclosing that, because there is a disclosure involved in a patent, because your patent application will be published, in disclosing to the world that this is how this invention, this new drug, whatever works, we will grant you a monopoly, an exclusive monopoly for this period of time, 20 years, for the duration of the patent. And so it's that bargain between the state and the individual, either the individual inventor or the individual company, that's at the core of what a patent actually is. And so a patent needs certain qualities. It needs to have certain qualities in order for something, whatever this is, like say a method, an apparatus, a system, a process, a drug formulation, whatever it is, they will always need to have certain qualities. And a patent goes through the process of examination, which in every jurisdiction that it's in, and a patent examiner will look at this and they will assess, well, is this, does this meet the qualities that we need enshrined in law for this to be protectable and patentable? And the first thing is, it has to be novel, it has to be new, and that's absolutely the very first hurdle that you'll encounter. And a patent is assessed for newness against essentially all of the art, what they call it prior art, but essentially prior art just means all of the knowledge that's out there in the world already. This typically will mean academic publications, but it can also mean other patents that are in there that have already been patented, or indeed patent applications that have been applied for that may not necessarily have ever been granted, but they're at application stage. And so usually a bit of work is needed to investigate what's out there. Of course, patents aren't, your prior art is not limited. What is out there in the world is not limited to just what's on the patent register and what's on academic publications. Anything, a video on YouTube can count as prior art against you. By way of an example, I dealt with a case where a student at one of the universities in product design had developed a really interesting and innovative barrier technology, which they were working with at that time, Dublin Fire Brigade and the New York Fire Brigade on. Fire brigades were really interested and thought it was really good. There were some novel aspects there that we thought we could potentially protect. We got into the patentability, the assessment of this, and it emerged that this student had put up a YouTube video as part of their coursework, and the YouTube video showed the barrier in operation, showed the apparatus, showed all of his workings in terms of how he'd gone through various different iterations of the sort of product design process to get there. So that video was prior art against us. It was out there in the world, it wasn't confidential, and that ruined the patentability on that particular case. So newness is absolutely essential, and it doesn't matter whether you've put the information into the world or whether someone else has. It's assessed against everything that is out there at the date that you apply for that patent. But it has to be new, it has to be unique. The second thing, and this is one of the most complex aspects to often get past in terms of the patenting process, is there needs to be something called an inventive step, or it's sometimes called the non-obvious test in the US. And essentially what this means is a patent examiner can look at an invention and they can say, okay, look, yes, this is new, but actually it's not inventive relative to the prior art. And this is where an examiner can take two things that are out there, put them together and say, look, yours is obvious when you look at both of these things combined. And an example, hopefully this isn't too sort of university centric, but an example is a diagnostic technology. To use that as an example. Let's say, for the sake of argument, that we have a diagnostic biomarker which takes gene X, and that gene is an indication of, we'll say, a certain cancer type. We'll say prostate cancer for the sake of argument. And that linkage has not been put together. It hasn't been expressed before anywhere in any literature, any patent, that gene X, is a marker for that type of cancer. So that's great, that's new, it's a new invention, and potentially that invention is patentable, it's protectable. The examiner comes back and says, okay, well look, yes, it is new, but there's literature over here that shows, this paper shows that gene X is linked to, let's say, another cancer type, let's say head and neck cancer, for example. Let's say there's another paper out there, a second paper, which links them prostate cancer, as the target, to maybe head and neck cancer. Actually, these are morphologically linked, and there is a connection here. And the examiner then argues that, well, look, based on these two papers, based on these two pieces of information, the link between biomarker X and this type of cancer would be obvious to someone skilled in the field. And again, someone skilled in the field is very well defined in patent terms. It means someone educated up to PhD level, essentially. There's quite a high bar getting over this inventive step question. It's really quite difficult. It's been massively difficult when we get into software inventions to get over the inventive step, at least in my experience. The next thing then, and the final thing that you need to have is sufficiency, something called sufficiency. And that really just means, that goes back to this bargain that I described earlier on between you and the state, you as the applicant and the state, which is that you're disclosing this knowledge in order to be granted this monopoly. Well, if you don't describe your invention or how to do it or how to apply it in enough detail that someone else at the end of your patent life can actually apply that, then you can run into issues with sufficiency. So you need to describe the invention in enough detail that it can actually be applied. That's in theory, if you've got the invention, if it's well developed, if it's well tested, that could be a relatively low bar to get across. So primarily the main bars are novelty and the inventive step, and then sufficiency sort of tend to be the thing that will sort of raise issues sort of least out of the three typically. Another thing to understand about the patent piece is that, look, people will sometimes think, and certainly be that inventors in the kind of academic context that I deal with, or even companies sometimes that I speak to, and we talk about patenting and the options with patenting a particular invention or not. And they will often think of patent as, it's almost seen sometimes as a virtue in and of itself. And I really don't think of a patent as a virtue, and I don't necessarily always even think of it as an asset. I always actually start out from the point of view of thinking as a patent. A patent is a liability. From day one, the patent is going to cost you money. And at that point in time, pre-commercialization, it's not going to earn you a penny. So that's definitely not an asset to me, and that's very much a liability. And so the analogy that I always use is that, look, filing a patent is like parking your car in the center of town. You have to feed the meter, and the meter is constantly running and constantly getting more and more expensive. And so this rather sort of complex slide is actually sort of the patent process from sort of concept through to filing, through to eventual sort of registration of that patent in different domains and different territories. To give you an idea of the sort of the cost implications on the timeline. Filing a first patent, I assume here you're going to use an agent, an external agent to do this and support you. But you can file a first patent application for about maybe, let's say, £4,500, say, for the sake of argument. All that does is buy you 12 months. You've essentially put $4,500 in the meter, and you've bought yourself 12 months. At the end of that 12 months, you have a decision to make. Usually that decision is where do you file nationally, and you have an option at that point to file something called a PCT application. And that could cost anywhere from sort of £6,000 to £8,000. And essentially at that point in time, you've thrown another £6,000 to £8,000 in the meter, and all you've done is bought yourself another 18 months. Because at that point in time, you don't have a patent granted, you don't even have a patent examined. Most typically, you may have a search and examination report back as part of the process, but certainly you don't have a patent, a granted patent at that point in time. So all that does, for the sake of that sort of maybe £13,000 worth of spend, is you've bought yourself 2.5 years. there's certainly what we do in the university, and the way I manage it within the university is we absolutely manage it to the nth degree. That is a relatively inexpensive stage of the patent process. £13,000 might sound like a lot. It's actually very inexpensive relative to the cost that will eventually come later. And so what we do in that first 2.5 years is we absolutely milk our technologies and try and validate them commercially and try and make sure that we absolutely have a home for this, have a commercial partner lined up, have a commercial route by the time that we get to the end of 2.5 years and we get to this next big question that has to be asked, which is the national decision and the national question. So the national question becomes about, well, what territories, what geographic jurisdictions do you want to enter into with this patent? Because bear in mind, a patent is a national right. There is no such thing as a worldwide patent. Every patent is granted in its own jurisdiction. There is cooperation, there is commonality of examination. There are ways that you can sort of draw the process together, but ultimately a US patent is granted in the US, a European patent is granted in Europe. They may have started out from the same original patent application, but they are different granted patents when they get to the end of their journey. So that's something to consider. All of that really means that there are 3 timelines when you're thinking about your intellectual property and the development of your product or technology. There are really 3 timelines that you have to consider when you throw a patent into the mix. It means that you have to think in parallel about how do you line up your commercialization process, your commercial journey, i.e. milking this asset to get to a realization of income. Align that to your funding piece. The commercial often ties in quite neatly as well, I think, probably to the development piece. Usually you'll have to develop something in order to get it to that sort of commercial stage. And then your patent timeline gets layered in then on top. And you need to, as best as you can, try and align these 3 timelines together so that your development, your commercialization is happening and you're not getting timed out in the patent, so that you're getting hit with big, expensive decisions at nationalization stage before you actually really have the information or really have the commercial insight or really have the sort of the funding in place to actually develop the technology itself. So it's really, really important at a university level for me to align those, but equally it's important at an SME to align those as well. So unless you're a huge company and can just throw money at this, managing these timelines is important because it allows you to manage the costs and the expense of the patenting process. So one question that I'll always get up, so just to preempt a question sometimes that will sometimes come up is someone will ask, can I patent this invention X, and they will outline something about their product or service or offering. But what I'd say is, look, if it is novelty, if it is utility, if it's not obvious, if you can describe it in sufficient detail, then the answer is most probably yes. Because at the end of the day, if you can get it, I could probably get into enough granular detail about this pen in order to patent that. But would that be useful? In the end summation of what would eventually be protected in such a narrow way within the context of this pen, would that actually be useful? So the more pertinent question that I would ask in your position is, should you patent this? And should you patent this takes into account something much broader than just, is this invention patentable? It takes into account, is it commercially sensible to patent it? Is it wise to patent it? Are you better off retaining this information as know-how? Because bear in mind, a patent will eventually be published. Everyone will know how to do that. Your patent has to be defensible. Your patent has to be capable of you have to be able to identify that someone is infringing in order to enforce that patent. So a patent that is going to, someone that could bake it in-house, you might never know that they're actually using this. Is it really wise to actually patent that type of invention? There may be other better ways to protect that type of idea. So that's a very quick overview on patents. And I've spent probably the bulk of the time there on patents because I think they're one of the most important, and I tend to get the most questions on patenting.
Yeah, I just have a wee question in there. Just going back to you speaking about YouTube, the video stopping the patentability. In your opinion, does that mean that you should avoid publicity or PR around, be it the idea, process or system before it's patented, until you actually apply for the patent? Should you avoid the PR stage?
Yeah, so look, the short answer is yes. So absolutely the short answer is, look, yes. But obviously there's a commercial element to that decision, and I'll explain the way we manage it in the context of the university. Within the context of the university, we develop inventions arising from our research, and publications and publicity via those publications is obviously core to what we do. So we have this, and academics are promoted and rewarded on the basis of what they publish. We have this very difficult balancing act of deciding whether to publish or whether to hold back. And what I will typically try and do is say, look, hold back the important elements, but try at the same time and validate the value of what the invention can do. And so, what we would typically do in that case is we would work with commercial companies to try and understand, look, is what this invention, what this invention can do, is that useful to you? Are those features, those qualities of the invention, those potential outputs, the benefits of that useful to you? Without actually getting into a lot of detail about how the invention works if we're sitting pre-patent stage. Now, there is a way that you can also protect from disclosure, and it's through a non-disclosure agreement. So if you communicate with the idea with someone on a bus, you're sitting on a bus, talking about the idea to a sort of person, and anyone around you can hear, potentially that's a disclosure. If you sit down, have a person or a contact or a company sign a non-disclosure agreement that says, look, we're going to discuss these things, these are confidential. Anything that you discuss in that context of the meeting is not then treated as a confidential disclosure for the purpose of patenting. So that's something to bear in mind. But of course, very rarely can you get to the stage of, of just saying to someone, look, I want to talk to you about my idea, but I can't even mention it without signing a non-disclosure agreement. Quite often people will do what I do in that circumstance, which is just say, well, look, forget it then, because I have no idea what you're talking about. I have no idea whether the conversation is going to be useful for me. You need to be able to share a little bit of detail. And so the little bit of detail that I would typically be comfortable sharing is usually around the end outputs, what the invention can do, as opposed to how the invention works. You want to protect what you ultimately want to patent, and usually what you're patenting is how this works, the method, the apparatus, the formulation. But you can certainly still try and validate that there's value in this before you spend the money by asking questions, having discussions about what this can do, and also by signing, when necessary, a non-disclosure agreement to make sure that that the detail of this is protected. And we use sort of both models when we were trying to take technologies out of the university and engage with industry. So, but the core message there is, yes, any disclosure could potentially ruin your novelty. So you do have to be careful and mindful. But there are ways that you can manage that and still achieve the commercial objectives. So, look, next piece, I'll be able to, my aim is to go through these hopefully much more quickly. The patent piece, which is worth sort of spending a bit of time on and concentrating on, is know-how. Know-how always comes up. It's worth getting into a little bit of detail on. Well, what is know-how? So the idea that we're talking about here, that you're going to protect by know-how, well, it's basically the same as a patent. It's still a method. It's still a system. It's still a formulation. It may be augmented by also being, a table of data, a set of exposure times, certain information on how something is done or operated. But the key with know-how, for that to be sort of actable as an IP, treated as a sort of an IP asset, which can be licensed, sold, dealt with, is that it's secret. So it's almost the opposite of a patent, in that you take your method, you disclose it in order to be granted that state-granted monopoly. Whereas with a piece of know-how, a valuable piece of secret know-how, you take that method, you take a view that, okay, well, look, this method is really difficult to get to. The big obvious example is sort of, people throw out, I don't know really how confidential it genuinely is, but is the Coca-Cola formula. So this idea that, well, if they had patented the Coca-Cola formula, that would be off patent 70 odd years ago. But retaining it as know-how, as long as that has remained secret and confidential, it's still an asset that can be protected and can be exploited and can be managed. So you're not really talking about much difference in terms of the idea. You're just talking about a difference in terms of how the idea is dealt with and how it's managed. And as I say, it's secret and confidential. So look, know-how, for the purpose of being protected and being licensed, needs to be secret. And so you need to sort of think of know-how in almost two different ways. On one hand, you've got your expertise. Your expertise is not necessarily secret. It's just the way you do things. On the other hand, you've got a secret way to do things, which is usually ideally written down, substantial, codified, defined. Usually it's data sets that have been written up or processes that have been written up and then are stored confidentially on a server. That's the type of stuff that I'm talking about as a secret way to do things. That's what is secret know-how. Your expertise that's in your head, that's just what's in your head. You're going to be able to take that out of the building with you. The secret way to do things is licensable, is protectable. And with that fine line between those two aspects of know-how really matters. And some people will be aware of the story of Anthony Lewandowski. He was an ex Google employee on the autonomous side of the house. He moved companies, and there was big litigation around this. Not only was there big litigation, but the feds actually, took him and prosecuted him for using trade secrets. And his issue was he was taking out laptops, he was taking out thumb drives of information that was the proprietary trade secret. It was the secret know-how of his company. He had walked out the door with whatever was in his head and be able to apply it. That's his expertise. There's very little anyone can do to sort of limit your use of that. But taking out laptops, taking out thumb drives, that's a different kettle of fish altogether. And this is obviously an example from the US where they're absolutely animals when it comes to this stuff. They have absolutely no qualms about taking out private, just an individual with a house and a car, taking them to court, taking them to federal court, to protect those types of trade secrets. So it's important to kind of think about. Certainly we're here in Europe and in the UK, it's not as, you tend not to have these types of really confrontational sort of litigation around the area in the same way that sometimes you'll see in the States. But it does happen, and it's really important that you manage trade secrets and you manage sort of know-how that you do want to keep it confidential. So, and one of the most important things is that engagement with employees, technical employees that are doing things, that are managing things. Those employees will eventually move. And so how is your know-how, particularly your valuable know-how, which is codified and confidential, how is it protected? Have you got appropriate employment agreements in place that cover intellectual property? Have you got appropriate confidentiality terms in those employment agreements? Or do you get the employees to sign a non-disclosure agreement when they're dealing with certain types of really important, valuable, secret information that you have to deal with? So that's an important consideration in terms of know-how. Software is sort of the next thing. Software is not an intellectual property right per se. It's an asset, but I wanted to talk about it because typically there will be so many software-oriented SMEs that we'll be dealing with. And software ultimately can be protected by know-how. Software can be protected by know-how in terms of how it works. It can be protected by patents in terms of if there's something genuinely unique in terms of how the software operates, but that is very unusual. It's a myth that software can't be patented, but it is very unusual that software can be patented because you often run into these issues of novelty inventive step because there's very few ways to kind of skin a cat when it comes to a software program in terms of how that program operates, and that's what you would protect with a patent. So the core piece of intellectual property right that you're dealing with usually in the context of the software is copyright. And so copyright is really, really important in this context. And so, copyright protects the articulation of the idea in whatever format that may be. So copyright is the written word. Think of it as the written word. People are most familiar with copyright as protecting a book, protecting a movie, for example. Copyright is really, really valuable in the context of software because it protects that source code. That source code is treated almost a book. The developer or the coder that writes that is coding it. It's treated as an original work, and that source code itself is then protected by copyright. Copyright's interesting because it's an immediate right. So you don't necessarily have to there are repositories that you can go to register copyright, but it's not something that you have to automatically register. It's a right that automatically exists as soon as that copyright is created. I tend to think of copyright as being an inch wide but a mile deep, and so if you articulate in a manual, for example, how to operate something, but you haven't protected, if you have copyright on that manual, You haven't protected the process that you articulate. You've protected the way it's articulated. You've protected someone lifting that manual, handing it to their staff and their company, and going from there. It's also really, really, it's really a very long intellectual property right in comparison to, say, patents. So I mentioned earlier, patents, you're granted the monopoly for a period of 20 years from your PCT application. A patent can be 70 years from the date of the author, from the death of the author. In the case of movies, I think it's maybe 70 years from the death of the director and first principal photographer and the scriptwriter. The last of those people to die, and then it's 70 years. So you can certainly see, if someone is working at the company, they're 30 years of age, they're a developer, they protect, they put that sort of source code together, then it's protected for a really, really long time. To be honest, in the context of software as a product will get moldy so quickly that there really is no need. You'll get no huge benefit from sort of 100 years worth of protection that might sort of exist in that source code. But copyright itself is a really, really valuable form of protection. The sort of the long-term sort of nature of copyright is probably most valuable within that sort of movie industry where movies are protected. And the publishing industry where movies and books are protected for such a long period of time. An interesting thing in the context of software, and just when we're talking about this copyright piece to think on, is that database rights are a thing. Database rights are a type of intellectual property right that should be understood and considered. Database rights sit under copyright legislation. And so while information itself is not necessarily protectable or capable of being owned per se, information can obviously be protected with secrecy, but so it goes back to that know-how aspect. But if you pull together a database of information, if you arrange that database in a particular way, if you have spent time and effort to pull that database together, whatever this database is, the Ryanair database, customer database is one thing that sort of springs to mind as being hugely valuable in terms of an asset, for that company. That is protected under copyright, and that database has has value. So that's something to bear in mind within the context of software as well. So just very briefly, I'll talk about the other buckets, buckets that I sort of mentioned on the first screen. And before we're 5 minutes from break, so sort of enough time to just cover these very, very quickly. Trademarks, really, really important within the context of companies typically, but less so in the context of universities. I have to say I don't get into trademarks, in too much depth too often. I, might have had 10 cases over the last 5 years where we've dealt with some sort of trademark sort of element. The key things to understand with trademark really is that there are actually two types of trademarks. Again, there's an unregistered and a registered format. So the R in the circle symbol is a registered trademark. It means that someone has applied to the Patent and Trademark Office and actually taken registration on that brand, that logo, that design, or even that word, a word mark is capable of being protected as well. And then the other thing that you'll sometimes see after someone's identity or logo will be the TM symbol. Now the TM symbol is different. It means that this hasn't been actively registered. It means what it is it's a tool for that owner of that brand, the person that owns that identity, but everyone else will notice that they are claiming trademark rights in that brand, but it's not a registered right. That still has value. That still has power, because you've put people on notice. It creates a potential liability for them if they do come in and try and clearly and obviously copy your brand. It's not as valuable as the registered mark. It's not as easily defended as the registered mark, but it still has value. It's certainly better than sort of nothing, within the context of your trademark. And the bottom line is, why do you want to protect your trademark? Why do you want to think about spending time on that? Well, really it comes down to, if you go back to your business name, if you go back to your product name, you spend time building value in that, in what it does, the functionality. You spend time acquiring customers. You spend time trying to create brand equity, trying to create an association between the customer and what you are or what you do and your identity. And so that's the point of the trademark. It's there to protect that brand equity that has been built up over a period of time. Data then is the next one that I'll flag, and this falls back a little bit into the know-how piece. Data itself is not necessarily capable of being owned per se, but it is capable of being protected and controlled if you think about it in that way. Design rights then is the last one. Very, very infrequently will I get into the area of design rights or work in manufacturing and aerospace engineering. We will get into it on occasion. Design rights again have two types. You get registered or you get unregistered rights. There's a European registered right that lasts for 5 years, which is renewable 4 times. Capable of being renewed 4 times. Or there's an unregistered right, that can exist in a design. Really, what a design right covers, it covers the ornamental look, the ornamental feel, the way something looks. It doesn't cover anything to do with their function at all. So if you want to cover the function of something, that's really where you're back to, well, either you protect it with a patent, or you protect it with know-how, and you simply just don't tell anybody. You hold back in that regard. So design rights are useful in the context of engineering applications and the like. And look, I suppose to kind of conclude this kind of initial section, what I'll flag is, look, there's different degrees of importance with different types of IP rights depending on the sector that you're in. So when we get into the life science space, which obviously I deal with every day, the university is heavily involved in new therapeutics, drug discovery, diagnostics. Patents are basically essential. You can't operate in the area and expect to commercialize your outputs unless you have a patent to protect that. The drug discovery partners that we work with, they expect a monopoly in order to protect the value of their investment, and that's the bottom line. So your patents are really, really important. Know-how, data, and so on all comes after that. Anything in engineering, typically you can't. It's difficult to protect as know-how. So once you produce a product and put it out there, it can be easily reverse engineered. It's difficult to protect how it works if it can be taken apart. And so patents and design rights are typically the important elements. And then in software, typically copyright is the most important thing. That's what you'll often rely on. But know-how, sometimes if you can black box elements of the way your software system works, that can be important. And don't write off patenting if it's a piece of software. If you genuinely have arisen at some novel way that the software operates, and based on all of your experience and know-how, you think that it is genuinely new and genuinely inventive, it's certainly something that's worth having a look at and investigating potential patent protection. But certainly, in my experience in the university, most of our software is not patentable per se. It's 1 in 20 will maybe end up in a scenario where actually it's the system that the software is implementing is actually protectable. So it is occasional, but it can be quite rare. So look, that's bang on time, 1:20, thankfully. Happy to take any questions now before coffee, but I've got a quick 5-minute coffee break planned in. And then what we'll do in the second half is we're all going to come back in the second half. And as Luan said, there are some breakout rooms then scheduled. We're going to get everybody into those breakout rooms. And really, it's a discussion for you guys. So hopefully there's going to be at least 2 people in each breakout room. I think there may be more, depending on the numbers. But if you guys could self-organize and take the opportunity to discuss your products and your ideas and your services. Now, don't give away anything confidential. Absolutely don't get into any layers of this is how it works. Describe at a high level the type of product, the type of service, the type of thing that you're doing. And really the aim of the exercise is for the other person or the people in the group, try and look back at what I've just discussed and identify what types of intellectual property right might be applicable for your business, and to have a conversation in those groups on that, and then take some time to switch. So if anyone feels uncomfortable getting into a discussion on that, absolutely no issue. You're free to jump off the call now, and you don't have to jump into the breakout room session, and you can certainly wrap it up there. You get the full slide deck and everything afterwards as well, so you won't miss out on anything. But it's just to give everybody a heads up that that's what we'll be doing after the 5-minute break.
Thanks, Dermot. Yeah, there are a couple of questions in the chat, but sure, we can go to a 5-minute break, come back just at about 26 minutes past. And Dermot, if you want to pick up those questions then, and then we can go into the breakout rooms.
Yeah, super.
Thanks, everybody.
I, we're back to recording. We're back to recording there. So Big Brother's watching again, and better mind my manners. Look, I'm going to pick at random, or actually, do you know what, Joanne, could you do me a favour, because you had sight of who was in the breakout rooms and who wasn't, and so you maybe recognise some of the names of everyone that was broken into those breakout rooms. So could you pick a name at random and give me that name, and I'm going to then fixate upon that poor unfortunate person?
Yeah, no problem. Fergus Walsh.
So Fergus, have we got Fergus on the line?
Are you?
If you're around, Fergus, stick on your car. There you are, Fergus.
Yeah, how's it going?
So Fergus, so you were in the breakout room. Were you doing the talking, or were you doing the listening in terms of the technology piece?
A bit of both, although I'm probably more familiar with my own situation than with the other person. So maybe I'll give you a brief rundown of mine. Is that okay?
Well, if you could, well, I suppose the interesting thing would be if you could give us an overview actually of the other idea and give us your sort of initial thoughts on what you think that company or that person sort of could be protecting. And then what we'll do sort of briefly is if that person then could sort of chip in and sort of see, does that sort of tally up with what they have actually done or are doing, if that sort of makes sense. It's doesn't want to sort of, it's trying to kind of embed sort of the learning to be sort of quickly able to kind of identify, look, broadly speaking, you've got this type of invention, it's a formulation, it might be patentable or whatever. So if you don't mind taking us through the other side of the table, that would be really helpful. Even just at a high level, if there are certain things that you identified that you thought that other company or team actually could have in place.
Yeah, I'll be honest, I'm not 100% sure. The other person was talking to the universities about when intellectual property was expiring. So I'm gonna plead a little bit of ignorance in terms of what their actual, it seemed like at a slightly different level that they were working.
Right. Okay. Gotcha. It was a bit more sort of university maybe focused. Well, anyway, take us through your pieces and I don't know, maybe it depends on you guys are advanced or, but in terms of your own sort of technology, what were the sort of the buckets, in terms of the breakdown, where did you sort of have a site that you guys might be able to protect, the type of assets, the type of intellectual property that you might be able to pick up on?
Sure. Yeah, I'm starting up a business and we're designing and manufacturing pet furniture for kind of a luxury market of people who have a high disposable income and are trying to make the furniture multifunctional, so it's for the pet, but it also looks really well in the home as well. So from what you were talking about earlier on, I think I was zoning in mostly on the design rights because I wouldn't necessarily say anything that I'm doing. All of our furniture is handmade. So therefore we're using, basic carpentry techniques that people have been using for hundreds of years. So I don't think in terms of patents or anything like that, there's no particular innovative process that we're using. We're using stuff that's really, been there around a long time. But I feel like perhaps the design rights, the registered design rights might be an area where we're looking at the piece we make. And if there's something particularly unique or special about how that entire piece looks, that's maybe where I zoned in.
Yeah, that could be the case with the ornamental shape and design. Now, again, there's a commercial element where you need to sit down and work out, are we going to be producing something of a particular design at enough scale, enough of these that actually protecting that sort of ornamental design sort of makes sense? Or are we, are these going to be sort of more, smaller runs, more bespoke pieces? The other thing really to consider for you guys in that space, anytime you're getting into direct to consumer type of sales, it's the brand, it's the, it's the identity. And how you break that down. Do you have a brand for the business, and then do you have different sort of sub brands per product line, sort of following on kind of like from kind of the BMW model, where there's sort of a 5 series, 3 series. They're almost like sort of sub brands within that sort of overall cluster, and they all have different messages for sort of different customers within that group. So I think you're right, design rights would be an interesting one to focus on, but I think as well, something to think about is that brand and that identity.
And that's in the kind of the trademark end of things.
In that trademark, yeah, in that trademark type of things, because certainly, I would assume that if you're a high net worth individual and you're procuring pet furniture, you're doing it and you're paying that money because of what this product says about you. And
Right.
so you're doing it because of what this product says about you. It's not just about the product, it's about the identity of that product and about everything that's sort of communicated within that. So really, really I think the sort of brand is it would be a really valuable aspect to get into some detail on. Maybe at least investigate how you sort of intend to sort of create that identity, develop that identity, and what makes sense in terms of trying to protect that.
Yeah, that's great. Thank you very much. That's very helpful, and this session was very helpful too. Thank you.
Super duper. Well, look, I think we ran on maybe in that breakout session a little bit as well. So I'll leave it on Fergus, and I won't get into the detail. I'm conscious I do want to get into just a quick sort of overview and maybe hopefully have a couple of minutes left for Q&A as well. But it's really the sort of the tips, hacks, and tricks piece. And the thing that I just really wanted to flag is that if you are a business and you are considering patenting, that lots of people will come to me and they will try and handicraft, as I would call it, home make their own patents, because they will go onto a patent website, they'll see how a patent is written and drafted, and they'll think, oh, I can do that. For the love of God, please don't. It's the false economy out of all false economies. Yes, patents are expensive. Yes, using agents are really, really expensive. Because, like I say, your first patent to draft it and file it will cost you maybe £3,500 at least, up to maybe £4,000, even £5,000. But honestly, in the scheme of things, if your patent is genuinely really, really important, that's worth it in the long run, as opposed to homemaking it yourself, spending £500, and you could sort of, absolutely screw the whole thing up because there's such sort of complex language that comes in the case of patent. I work in the space. I'm very, very afraid with it. I would not even dream of drafting my own from scratch. I might be able to give the agent a very clear idea of what we want to protect and exactly the sort of the technical detail. I might be able to reduce costs that way by managing the time that the agent spends, but I would never ultimately draft that entirely myself and file it. So it really is a sort of a false economy to go that route. And a surprising amount of people do it. I've seen small one-person band inventors in their garage that are starting out with a product. They sort of home make a patent. They then eventually sort of forget to go into national territories. They end up with a sort of a half-baked patent in the UK only, and maybe they've sort of actually lost out on what could be a very valuable invention. So it's really well worth investing in an agent. If you think that an accountant is worth investing in, an agent on your IP is absolutely worth the investment and more. IP is a thing. It's actually a real thing. It should be, it shouldn't be considered ethereal. It shouldn't be considered a fugazi. It's something that should, whatever type of asset it is, capable of being written down. Even if it's that know-how element that I talked about, it should be a way of operating, a way of doing something. You write it down, you store it. I know that's easier sort of said than done when it's, say, you're trying to deal with employees and customers and all of that. But trying to break out time once every quarter to codify it is really sensible. Have a disclosure process. If you're a bigger business and have some staff, have a disclosure process in the business for those technical staff, so engineers, software developers, where they can disclose something that is new. And consider as well, you don't have to do it, but consider a reward mechanism, something to incentivize those staff to actually disclose that to it, because there's nothing worse than actually, this sort of the Anthony Lewandowski scenario where, he feels the need to take away all this good stuff out of Google and take it somewhere else in order to be rewarded, because really if rewards were adequate in the first place, that probably would have never happened. So I'm certainly not going to say, look, it starts going out sort of $1 million checks for early stage inventions, but some sort of reward process, recognition process is often enough to kind of incentivize technical staff to disclose these types of really inventive outputs. Think about employee agreements. That's probably one of the core things that you could probably do day to day. Have IP assignments and IP terms baked into your employee agreement. Deal with confidentiality so that know-how is protected. And don't forget contractors. Anytime you use a contractor, especially if it's, say, a software developer that's coming in, contracted to do a piece of work and build a piece of software, if you have no agreement with that party, they will own their own IP. They will own the copyright in what they produce. You obviously can't have that. You paid for a piece of work. You don't want to build the value in this and have to go back to them 2 years later and get it assigned to you. So whether it's a contractor building your brand, whether it's a contractor writing a piece of software, make sure that you also have agreements in place with them as well. And they should deal with the same type of thing, IP assignments and confidentiality at the core. And then with patent filings, if you are going ahead and doing a patent filing, you generally speaking, start out with a GB application or a European application. You will get a better quality of search. You ask for a search report and an examination report back. You'll have to pay slightly extra, but you'll get a better quality from those two offices than you will, say, from some of the smaller regional offices. And they're really sort of valuable from a sort of an investor point of view. They'll really give you a very clear steer and direction. If you're in the life sciences space, consider going for a European at the first filing stage, although it is a little bit more expensive. So those, just very briefly, then those are just a few hacks and sort of tips that I kind of wanted to cover and just make sure that we're sort of underpinned, throughout the whole piece. Other than that, guys, that's me. That's the session today. So look, I appreciate your time. I appreciate you staying on and taking time out of your day. I know it's really difficult to break out time for this. So that was, hopefully you found that useful. And any queries at all, do feel free to come back to me, to reach out to me in Queens, or if you want any of the contacts at Invest NI, Enterprise Ireland, or any of those agencies, do feel free to let me know, and we'll point you in the right direction.
Thank you very much, everyone. We will share the recording of today's event along with the slides from Dermot's presentation, and also a feedback summary document as well. If you could all participate in that, that would be great. But thanks to Dermot as well for his contribution today, and I hope everybody has a wonderful afternoon. Thank you.